Our court system. Here are the basics. The purpose of our court system is to resolve disputes. Every society has some sort of a mechanism, some sort of a system in place to resolve disputes. Every society through history has had something to resolve the disputes that arise naturally among the members of that society. Now, our dispute resolution system is through our court system, and it's called the adversary system. Components of the adversary system are that it sets up a contest between the parties over the facts in a dispute. Could be a breach of contract. It could be someone has committed a tort, a wrongful act against someone and injured that person. Whatever the dispute is, it could be a dispute over property. Whatever that dispute is, we have a contest between the two parties. And what they are contesting is the facts. Both sides present their best evidence and their best argument to say that they are in the right. And then, of course, the strongest case in this competition, the strongest case that comes out of that competition will be the winner. And out of this process, we have truth emerges, and then the dispute is resolved. That doesn't mean everybody likes the result, but at least the dispute has been resolved and we move on. There are set rules of procedure and rules of evidence that will apply in this contest. And it's the judge, the job of the judge, who is a neutral judge, to assure that that contest is fair under the rules of procedure and the rules of evidence. What the judge is doing is interpreting law or rules for that contest. And then, well, who wins the contest? How we decide that? Well, that's done by someone we call the fact finder. And that fact finder might either be the judge, or it could be a jury. But it's that jury or that judge who we call the finder of fact, or the fact finder, that determines what the facts are in the case. And then that will allow the judge to apply the law, to decide what law applies, and then the winner is then determined from that. What are the duties and powers of our court system? Well, as I was already saying, it's to resolve disputes. But beyond resolving disputes, our court system interprets what the law is. We have a number of sources of law. Law can come from the legislature. Law can come from city councils in the form of ordinances. Law can come from administrative boards and commissions in the form of rules and regulations. Law can come it exists in the fundamental law of the political system, the Constitution, whether it's the U.S. Constitution or a state constitution like the state of Texas. Law can even come from other previous court decisions, but it's the job of the courts as they resolve disputes, they are naturally going to be interpreting the law from these various sources. Now, when the courts interpret a law, that's not necessarily the final word. The legislature can always or frequently go back and change the intent of a law, if it's a statute, to clarify the legislative intent. And then the court has to follow that legislative intent and that clarification. But the courts always can review, and that's another duty and power of the court system, this judicial review. Courts can always review the decisions of lower courts, the decisions of the legislature, legislative acts, the decisions of executive boards and agencies. They interpret those, and if they find conflict with a higher level of law, like the Constitution, for example, well then those laws can be set aside and be invalidated by the decision of the court. And that's what we call judicial review. Courts in this process then that we're talking about even essentially make law. We've always been taught throughout our schooling that legislature makes the law, the executive branch applies or executes the law, and then the courts interpret the law. Well, the courts do more than just interpret. The effect of their interpretations is basically making law. And that can come in the form of what we have come to know as the common law over many centuries. Courts will add to that and modify that common law, which is judge-made law. Courts, as they interpret current law, are basically making law by saying, well, this is a new interpretation of the law, of a recent statute or the most recent court case. We're going to change our interpretation of that. And that new interpretation essentially becomes law. Let's talk about some terms that are important for understanding our judicial system. First one is jurisdiction. Jurisdiction is the power or authority of a court to hear a case, to make a decision. And we have several notions of jurisdiction, several concepts of jurisdiction, how this would apply to the types of cases a court could take, and whether it can even exercise jurisdiction over a case. The first of this is geographic jurisdiction. The idea that there are going to be some cases that have to arise in a particular geographic area for a court to hear that particular type of case. For example, a speeding ticket written by the city police in one city could not be tried before the municipal court of a different city. There's a geographic jurisdiction limitation there. Second one is what we call personal jurisdiction. Just because someone wants to file a lawsuit against someone, believe they have a claim against someone, doesn't mean that that particular defendant can be brought before whatever court the plaintiff wants to file the lawsuit in. A court must have jurisdiction over the person of all the litigants. Well, we assume that the court will have jurisdiction over a plaintiff that walks into court and files a lawsuit there. But that's not necessarily so with a defendant. Defendant must have significant contacts with that jurisdiction, must have the cause of action, the lawsuit must arise in that jurisdiction. So for there to be personal jurisdiction over the person of the defendant. And then we have subject matter jurisdiction. Not all courts can hear all kinds of cases. Certain courts are limited to hearing certain types of cases. You won't have a justice of the peace hearing a death penalty case because the justice of the peace does not have subject matter jurisdiction. Other notions of jurisdiction that you may hear: general jurisdiction. That's generally referring to a court that would generally hear general types of disputes, district courts, for example. But then you have lower courts, lower trial courts that might be called courts of limited jurisdiction, where the subject matter jurisdiction would be limited in some way by maybe the amount that's in controversy. More about that in a moment. Original jurisdiction, courts that have original jurisdiction are those courts that are trial courts and they hear a case for the first time. Appellate jurisdiction, those are appeals courts, courts where cases are appealed after they are tried. Concurrent jurisdiction, that means that there's more than one court that could hear that case at that point in time. There may be a couple different trial courts, a district court and maybe a county level court that could both have jurisdiction to hear a lawsuit. And so we call that concurrent jurisdiction. Plaintiff generally gets to decide which court to file in. Some other important terms, we have diversity of citizenship. That's a concept that's important in determining the power of a federal court to hear a case. It's the idea that all the parties before the federal court have to be from different states. You can't have plaintiff and the defendant from the same state. There has to be diversity of citizenship from all the plaintiffs versus all the defendants. Amount in controversy, that's the amount that the parties are fighting over. And that's frequently a basis for subject matter jurisdiction, and it's also part of the jurisdiction of to get into federal trial court. Domicile, that's important because that's where a person's permanent home is. And so that can be a very important concept when we're talking about jurisdiction of a court. Venue is not the same thing as jurisdiction, but it's closely related. Venue basically means place. Should the trial be held in this neighborhood? A court may have jurisdiction, but it might not be the right neighborhood to hear for that particular case. So it is also an important term. We've all heard of a change of venue. Structure of our court system, both federal and state systems have two types of courts, trial courts and appellate courts, and we've already made reference to those. Trial courts hear a case originally and determine what the facts are. Appellate court, they look for error as they review lower court cases. Now, and it's the trial courts that determine what the facts are, and the appellate courts determine what law should apply. All federal court or at the federal court level, and most state court systems have their court systems arranged on three levels. Trial courts are at the bottom. Those are typically called district or county courts, or maybe just of the peace court or municipal court. Intermediate appellate courts are going to be next, and that's to where cases are appealed for the first time. And then we have courts of last resort. Frequently, those are called Supreme Court, although some states, like in New York, their top court is not called the Supreme Court in New York. That's actually, their top court would be called the New York Court of Appeals. So different states may use different terms or titles for these courts, but for the most part, most states have these three levels: trial, intermediate appellate court, and court of last resort. And then finally, a word about the personnel that we find in the courtroom. We have the judge. We've talked about the judge could be appointed or elected. On the federal level, they're all appointed. Some court systems will have, particularly like in Texas, will have frequently another judge in the courtroom that's chosen by the sitting judge. This is called an associate judge. Sometimes they were called a master or a referee, and they help the judge with the caseload. There's also going to be a court reporter in many of our courts. If there is no court reporter, that court is not what we call a court of record. There will frequently be someone who will coordinate the docket and control what cases are going to be heard when, and help the judge with the scheduling. We call that a court coordinator. The clerk handles all the paperwork. The bailiff keeps order and is in charge of the jury when we do have one, and also in charge of any criminal defendant that happens to be in custody. Then, depending on the court, there may be some others. There may be a process server, a probation officer that's present in the courtroom in the case of criminal cases. There may be an auditor or an investigator that works in probate or guardianship cases in some jurisdictions. And then, of course, frequently you'll find someone who is an interpreter. And so that's, in a nutshell, information on our court system. Here we go.